Hi, this is Curt and welcome to another edition of Fire Law Roundup.
Okay, so now let's go to New York for a moment, and let me just preface with this, because hopefully people have been following it. It's certainly very interesting. And I'm going to let you talk most of this because, again, I know personally some of the players, but I want to give some procedural background if people are saying, why is there a second suit? So what we have here is in the state of New York, city of Watertown, we have the firefighter who he was a recruit. He was at the New York State Fire Academy in Montour Falls. He died immediately after or while in the maze, the SCBA Mass Confidence Maze, which is a grueling maze. I've done a number of times. They sued the state of New York, and they sued the state because, of course, they're state fire instructors, et cetera. And in New York State, in order to sue the state, you have to sue in a certain state. And you sue in this New York State Court of Claims, which I had clerked in for 2 years, many years ago. And in that court, only the state may be sued. So what we have today, and I'll let you pick it up, is now we have the counterpart, which is annoying as an attorney, at least as a plaintiff's attorney. It's annoying that you've got two suits doing the same thing in two different courts, but now they've sued the individual instructors because they can't sue them as part of their suit against the state in the Court of Claims. They have to sue that in a trial court, and that's what they have. And they've named the 5 or 6 instructors. And disclosure, I know some of them. I know of some of the others. So I'm not going to comment much on the negative side, but maybe, negative side. I'm probably going to, just full disclosure, comment mostly on their side.
Yeah, and I'll take the plaintiff side in this, just so that we have a fair discussion of the issues, and I think it's given your closeness to it, it probably makes a lot of sense. But the parents, I guess, are saying to some extent the fire academy is responsible, but because it's run by the state, had to go to the Court of Claims, but the Court of Claims doesn't have jurisdiction over the firefighter. So you got one suit there, very similar allegations. And the allegations are the firefighter was going through some sort of a maze and indicated to the instructors that he wasn't feeling well and
couldn't breathe. I think I think he said, I can't breathe. And they said, if you're talking, you can breathe, something like that.
Right. And so, again, there's a lot to what I'm going to get into on this, but at any rate, he told the instructors something. The instructors gave him something back. Bottom line is he continued in the exercise, and then he goes unconscious. Soon after, they're doing CPR. There was no defibrillator on the scene. There was no ambulance to transport him. He ended up being transported on a bus. So all of those things are sort of in the mix, particularly as far as the fire academy goes. I mean, the individual instructors, they can't sort of wave a magic wand and come up with an ambulance or come up with a defibrillator. But at some point, there's some responsibility in the fire academy. There's some on the instructors as well. What I think is interesting, and this is sort of consistent with a number of other lawsuits that I've got in my database, there's a condition, and you saw me kind of looking around here. I was trying to find, because I want to get this right, but it's called rhabdomyolysis or rhabdo. Have you heard of that?
No.
RHABDO. This is from Dr. Verone. So live from the resident trauma surgeon, or the trauma fellow at Baltimore Shock Trauma. But it's a condition that happens when someone is, for example, somebody running a marathon, and they have this massive muscle breakdown. And certainly somebody who's going to run a marathon, they've been training for it and their body's ready for it. But if you're not in that kind of condition and you have this rapid muscle breakdown, you get a lot of tissue damage or tissue breakdown, and it overloads the kidneys. It puts the body's metabolism into a condition where it just can't function, and they end up in cardiac arrest. And it's something that I know my brother, I think we talked about this recently, but my brother was a drill instructor in the military. And before they allowed him to be a drill instructor at boot camp, he had to be trained in this and, told what to look for, how much hydration folks need to have, how far you can push them, symptoms or indications that somebody is entering this kind of very, very dangerous condition. And there's a question about whether or not the instructors were actually aware of this condition. And I'm really glad I called a friend of mine, Mark Pear, who is the director of our fire academy here in Rhode Island. He was a colleague. He and I came on the job together in Providence. We went through the ranks together. And as soon as I said it, he goes, yeah, Rhabdo. And I'm like, you know about it? And he goes, yeah. We train our firefighters. We train everyone on this. So it's reassuring to me to know that the word is getting out about this. But I think, and they didn't use that term in the complaint, but I think that's what we're kind of getting toward, that, there's a question about whether or not the instructors were properly trained, whether or not they properly recognized that he was having this type of a condition or something comparable. Maybe it wasn't exactly this, maybe it was something else. Right. And they failed to recognize it and then, get him whatever he needed before he actually went. So that's the thing. And one more thing, and I know you're itching to jump in. All right. But one more thing with regard to comparative negligence, we don't have to show that the fire academy was 100% liable. We don't have to show that each of the instructors was 100% liable. We've just got to show that somewhere there was some degree of responsibility, maybe 33% on the fire department, 33% on the instructors, and you're still going to prevail. It's just the overall damages is going to be reduced by whatever that percentage is. So again, you don't have to show that someone was the only cause, but you just have to show that there was some percentage of fault in there.
And here's kind of my take on it. And listen, for everybody, I'm intentionally playing the other side of this, right? As Curt and I go back and forth. But so first, as I think I said last time, so I am authorized and took the courses at the State Fire Academy. I'm authorized by the state to teach both the Firefighter 1 series and specifically an additional course of SCBA Mass Confidence. So I can teach both those courses. So I'm well familiar with what I was trained in. Right. And that ain't any of it. Let's be clear. The fatigue of firefighters was not, to my recollection, in any of the of what I was taught. But here's the thing. When we teach SCBA Mass Confidence, when we teach the Firefighter 1 course, we are given lesson plans. We are given a curriculum, right? So we are given the course knowledge and the method of teaching. Mm-hmm. But so all they did, right, I would argue, was follow a plan given to them. It is not really discretionary. They teach how they're given, right? I can't make up the course. And so that's what they're given to teach. Now, so the question is, was the state negligent? One question in my mind is, was the state negligent for failing to provide that type of training? And I would argue that any instructor, right, who's going to teach any course probably should be given some training in recognizing medical conditions, et cetera. That being said, that wasn't part of any course. And I think I could teach 12 or 13 or so state courses. That's never been part of it, whether it's been teaching auto extrication or out in the sun, or I could teach live fire training, right? We teach all the whole 1403 live fire stuff, but we don't teach about recognizing medical conditions. We teach how to deliver the course. So I don't know that an individual who is told this is what you need to do in order to deliver the course material is going to be found liable for not recognizing a medical condition when it's not part of their training. Yeah. Now, the state may be liable for that. They may not be, right? I don't know. I don't know what the industry standard is. New York is a pretty aggressive state with firefighter training, and they're constantly reviewing and revising their course materials, and they're doing instructor updates all the time. I have a hard time believing that anyone's going to say they were negligent for this, but then you get to the second question. Let's go on the generic facts that, he says, I can't breathe. And they turn to him and say, if you're talking, you're breathing. Now, in fairness, I've had that said to me, or around me. I never have a problem. I can go 40 minutes on a 30-minute cylinder, but that mask course is tough. I know the exact one. I've done it a number of times, but I've heard the instructors say, I'm not saying these specific instructors, but I've heard instructors, first of all, we don't do you run like a this and you're a weak child. We don't do that anymore. And nor do they do that at the academy. They clap, they cheer. They're like, you can do this. You can make it. They egg you on to like, you come on, you a little bit further, or look for the way out, or look for another way, right? They want you to succeed so that you can succeed when you're trying to get out of fire. But now all the time, people say, I'm having a hard trouble breathing. I'm tired, exhausted. I want to quit. And they keep saying, you can't quit. You can't quit. Now, that's generally what they said. I don't know what they said here.
By the way, if you go to a marathon, that's what the people are saying the whole way. Keep going.
Yeah.
You can do it. You can do it. You can do it.
And don't forget, to get into the academy, you have to be provided a letter from your municipality that says you were given a physical. And I think it says consistent with your municipality's physical standards. Let me throw, if they're listening from Watertown, I may have a new one for you, right? And I don't mean to do this, but so I think the form, I haven't looked at it for a while, says consistent with your department's physical fitness standards, and you're certified to be in good shape. I think that the firefighters and the state have the ability to rely on that you were given medical clearance to perform the duties. Now, this, I doubt, is anywhere in there. I haven't looked at it to this regard, but what if there are no physical standards from your department, which, as we know, is in most cases? Or what if the state doesn't have a physical performance requirement such that it would give a doctor the proper way to evaluate somebody's medical health to do what they're going to do? Maybe the doctor says, I didn't know they were going to be going through mass confidence, wearing 60 pounds of gear, breathing on air, crawling, and, for 30 minutes or whatever at a time. I didn't know that. So I could come up with a lot of reasons, but I just have a hard time finding negligence on the state's part, or definitely not on the instructor's part, when they were just following the method of teaching they were given.
Yeah, I think it's less, honestly, less on the instructors, based on what we know. I think it's less on the instructors, more on the academy. But this, and again, I'm going to put the spelling of it on the blog when it comes out. But it's RHABDOMYOLYSIS. Blah 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 blah.
Right.
Okay, that's shows my one shortcoming I have is I never took Latin. So and it doesn't even sound like anything I've talked about or learned about in any of my science classes. But rhabdo is the condition, and it's a fairly well-known condition, and we should be training our instructors in it. And another thing about it, somebody could be perfectly physically fit. They could be perfectly physically fit, get by a doctor's physical, but then over the course of 2 or 3 days of training, be so depleted in terms of their energy reserves and various things that they find themselves in this condition. And that's where the instructors need to be trained. And again, I understand the instructors may not have been trained in it. That doesn't explain why the fire academy isn't aware of this. And I'm kind of surprised in some respects that state OSHA didn't look into this aspect of it, because an employer is required to provide a workplace that's free from recognized hazards. This is a recognized hazard, and it's not a new hazard. In fact, it's often associated with marathon runners, but the whole idea of a marathon came from the Greek, I believe it was a Greek runner who ran with a message and then died as he handed the message off. That's what we're talking about, rhabdo. This isn't something that just, came on the scene. This is something that goes back thousands of years, our knowledge of it, that you can literally run yourself to death. And that it's really up to the folks that are running the academy to recognize that this is a problem and take steps to prevent it. And like I said, my brother went through 7 weeks of training. This was 30 years ago, 7 weeks of training to make sure you don't kill a boot in boot camp. And
Right.
they studied this.
Right.
So I sometimes I think our instructors have watched Full Metal Jacket, and they think that after they watch Full Metal Jacket a few times, they're ready to be instructors, and they have the substantive knowledge, all of that, no question. But there's another component of it.
But we still only know what we're told we need to
That's
know,
right.
right? So
Absolutely.
I never thought of this issue, never through all my time in instruction. And look, at every course I run, I was a municipal training officer for 6 years. We always started with a safety briefing.
Yeah.
Always. And it always included, if you don't feel well, tell us immediately.
Yep.
Right. And you're done. You're done for the rest of the time.
Mhm.
But nonetheless, so maybe I would have done it differently when somebody says, I don't feel well. Maybe we establish a code word. All right. Like on scenes, we say we're
Palomino.
Yeah. Right. So I don't know, but I guess my final thought on this is really, we're taught to be an instructor by the state. So how we act, what we know, what we think we need to know is a product of what the state teaches us. So I don't find fault with the instructors if they weren't properly trained. And the question then is, okay, you may say the state is liable for not providing that training, for not mandating a couple of hours of training on health conditions or what to do. Mm-hmm. But is that a discretionary task? Mm-hmm. Right? I mean, this is one death in decades. One death in decades. So it's going to be hard
at that fire academy.
At that fire academy. But
I'm looking at it nationally, Brad. I'm telling you, I never thought about this until I started doing what I'm doing. And I'm looking at all these lawsuits, and I see one in Jacksonville, Florida. I say, oh, that's interesting. I see another one in Frederick, Maryland. I go, wow, that's another one. And then Chicago. And then you're like, holy cow, this is not isolated.
Yeah, my favorite, I was lecturing a while ago at a national health and safety conference, and I remember talking about crosslays and the netting that goes over it. Yeah. And I put up pictures, and the article name was always the same, freak accident, right? And I put up like 10 or 15 freak accidents, girl killed, freak accident, old man on a bicycle killed, and I'm like, it's not really a freak accident when you start looking at it. That said, and you would think the state would be charged with that duty to at least provide that training, but I think that's a tough road to hoe. They may have been wrong, but negligent is a different issue. And I also question whether the standard is going to be negligence. I'm not totally sure we're going to have a negligence standard. Maybe it's gross negligence. I question what the state can be charged. But in any event, that's where we are, and it's going to be interesting to see this play out. I have to think that I think there's maybe also a tactical component here, just so you know, of suing the individuals, because they are likely to turn on the state and say, well, this is the only training I was provided, and they didn't tell me, and I never knew, and had I known, I would have done things differently. So I think there is a tactical component of why you sue the members, because listen, they're never going to be personally liable. It's all vicarious liability for which the state pays anyway. So there's no reason to sue them separately. You're going to get their testimony, right? They may not be on the hook, but they don't have any money. Let's be fair. Not the type of money for a wrongful death. So I'm thinking it's probably a tactical reason that they want to get them to testify against the state.